FAPA did not create new motion types. FAPA created new grounds or bases to make arguments in motions.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today on The Weekly Friedman, we're covering an important procedural win for lenders navigating the Foreclosure Abuse Prevention Act, or FAPA, challenges in New York. In Palm Avenue Hialeah Trust v. Knowles, the Queens County Supreme Court granted the plaintiff's motion to re-argue and reverse its own prior decision that it dismissed the foreclosure as time-barred under FAPA. The court agreed that simply citing FAPA isn't enough. Defendants seeking to vacate a foreclosure judgment and dismiss a complaint must first establish that statutory grounds exist under CPLR 2221 or 5015A. In this case, the borrower failed to do so, and as a result, the foreclosure action is able to proceed. Joining me today is our senior appellate counsel, Stephen Vargas. We'll break down why this decision matters, how procedural missteps by borrowers can limit their ability to assert FAPA defenses post-judgment, and what it means for foreclosure litigation going forward. All right, Steve, thanks for joining me again. Unsurprisingly, we're back with another FAPA podcast.
It feels like we're talking about this all the time, but there's good reason to.
So I like this case. And the reason I like this case is because I think we're almost hitting like FAPA overload, right? And I think what you're seeing here is a borrower who raises FAPA, right? But doesn't really use any of the new FAPA protections, we can call them, to explain a reason why a case should be dismissed. Is that right?
Precisely.
Before we even jump into the case, are you seeing this a lot where there are a lot of cases where the FAPA protections are not being fully explained, but FAPA is being cited?
It is happening. In this case, it was done through an attorney, which is more surprising than, let's say, if it's raised through a pro se litigant. I think the foreclosure defense bar, by now, 2.5 years after FAPA was signed into law, across the board, and the pro se litigants even, are well aware that FAPA exists, that FAPA amended statute of limitations related laws and rules within the state, created new arguments defendants can make to try to secure dismissals based on statute of limitations defenses. But what FAPA did not do, and that's what this case illustrates, is create new procedural statutes that substitute motion types. And that's a very broad term, a motion type. FAPA did not create new motion types. FAPA created new grounds or bases to make arguments in motions. But the motions themselves, there were previously existing statutes, and those statutory requirements as interpreted by case law would still need to be satisfied in order to properly interpose a FAPA defense. FAPA in a vacuum did not just create a new type of motion you can make.
Let's unpack this because this is a little complicated. What exactly did the borrower's attorney say in this motion to argue that FAPA should result in a dismissal?
What the borrower's attorney did was, the borrower's attorney filed a notice of motion and then a supporting affirmation, and identified two FAPA statutes referencing FAPA itself, and then two of the chapter amendments that resulted from FAPA as the bases to move to dismiss. CPLR 2214 is a notice of motion specific statute. It imposes specific requirements that a notice of motion must identify the statute you're relying on to make your motion. And the supporting affirmation or memorandum of law in support of a motion needs to address those statutes as well, showing why they're applicable, explaining why they're applicable, why you're entitled to relief. What the borrower's attorney did was merely cite FAPA, the CPLR 213.4b statute of limitations itself, which is just imposing a 6-year time limit. That's all it does. And then FAPA 1501 subsection 4, which is just a statute that allows you, a homeowner, to seek cancellation of the mortgage in the event the statute of limitations expires. So essentially, the borrower, rather than citing a type of motion that the borrower was making, just said, I'm citing the statute of limitations and then a mortgage cancellation cause of action statute as the bases to make the motion, without actually citing any motion type itself. And when I say motion type itself, that may sound ambiguous because it's something we don't talk about much. But the listeners will be aware of a motion to dismiss, a motion for summary judgment, a motion to vacate, a motion to re-argue, a motion to renew. Those are statutes we typically talk about. And when a FAPA amendment is raised, it's almost always raised by relying on one of those procedural statutes. That's not exhausted entirely, but that's a pretty comprehensive list. None of those statutes were mentioned by the borrower's attorney.
Is this just a typographical procedural problem? Like, if they file this exact same motion but they do list one of those motion types, what would have happened?
It was fatally defective because the borrower did not reference any of those statutes. If the borrower, through counsel, actually raised one or more of those statutes, then it would have been possible for the borrower to actually properly interpose arguments based on FAPA. I still think there was one more defect because the borrower's attorney didn't, in my opinion, sufficiently address which FAPA amendment was being relied on, because the statute of limitations itself, 213.4, and then 1501.4 cancellation statute were not created nor amended by FAPA. They existed for decades. FAPA amended 9 or 10 other statutes or created new statutes affecting the statute of limitations interpretation. The borrower's attorney, in my opinion, didn't sufficiently articulate which 1 or 2 or 3 of those applied. Instead, the borrower's attorney just said, based on FAPA, just the acronym, and the existence of a statute of limitations, the action should be dismissed. And by virtue of the existence of a cancellation statute, the mortgage should be declared invalid.
So let's say they had listed a motion type, right? They had done that properly. And then they had properly tied it to the statute explaining why the case should be dismissed. They still have to explain factually what happened, right?
Correct.
Like, didn't they fail in that area also?
There was some factual discussion of why they believed that a FAPA amendment should be applied to the case. But to your point, there was another fatal defect that the court didn't get into as much in its decision because the court just said procedurally, quote, the motion was invalid. And I'm going to quote from the decision just because it's really important. And then I'm going to transition into the second part that wasn't discussed, but in the event it was discussed, the bank would have prevailed, I believe. Quote, the defendant specified in his order to show cause motion that he was seeking dismissal of the action based on FAPA, CPLR 213.4, and RPAPL 1501. Plaintiff correctly notes that these statutes do not provide mechanisms for dismissal or relief from prior orders or judgments. Instead, those statutes provided for, among other things, sweeping amendments to existing statutes and the statute of limitations for foreclosure actions. And that's just quoting verbatim what the court said, we were paraphrasing earlier. But to your point, and the court mentioned it here, this was a post-judgment situation. In a post-judgment scenario, the one statute that applies is CPLR 5015, which allows you to vacate an order or a judgment. CPLR 2221, the re-argument renewal statute, typically does not apply to a post-judgment situation. Typically, that statute becomes inapplicable once the judgment's entered and your time to appeal a judgment expires. So I think in this case, if the court had reached the merits of, let's say, a properly interposed 5015A motion where the defendant made some arguments about FAPA and actually cited an amendment, I still think the court could and should have denied the motion on the merits, saying in a post-judgment situation, the defendant did not explain how FAPA would allow a borrower at the sale stage to get relief dismissing the case without satisfying one of the subsections of 5015A. And that talks about lack of jurisdiction, excusable default in opposing a motion of some other type of deadline action. And in the FAPA context, it doesn't apply. Really, the only statute that exists to try to re-argue based on changes of law or renew is CPLR 2221E. But I do think either way, in a post-judgment situation, the judgment's final, and the borrower would have a very difficult time articulating why any statute exists that allows it to challenge it so belatedly. So I think even if the court had not denied on procedural grounds for defective motion papers, I think on the merits, if the court had gotten to that, the bank could have prevailed as well. But it would have been more complicated to get to a merits-based discussion when the easiest basis to win these successfully opposed FAPA motions is to find fatal procedural defects. Don't get to the merits. Don't get to the timing of certain acts or omissions. Just say the motion's defective on its face, and that's enough. Because oftentimes courts will say, even if a motion's potentially valid, the fact it's fatally defective for some particular reason renders us not required to get to the merits. Just a quick summary denial, procedurally defective, denied. And that's what the court did here because that was what it was required to do. Defective motion doesn't have to get to the merits.
I think the FAPA conversation is an ongoing one. And this is just another part of it. Thanks for joining Stephen Vargas and I in the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.